హలో 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 నాకు నేను లోపల హలో అని వచ్చేసారు. డిలే ఉన్నాయి. అయితే అవునా స్టార్ట్ అయిపోయింది.
Outside, please come inside. So good morning to all. Energy பத்தல யாருக்குமே எனர்ஜி இல்லையா காலையில. So we are done with civil portions. Okay. We are moving on to how to institute a criminal proceedings or how to file a complaint. Okay. So I hope you people are well versed with CRPC. First of all, please settle down. சீக்கிரம் உள்ள வாங்க. Shall we begin? Likewise, in civil courts, we have the hierarchy of courts, right? Hierarchy of courts இருக்குல்ல. Lowest court, then comes the subordinate court, then comes the district court and high court. Likewise, which section of CRPC deals with the hierarchy of courts or constitution of criminal courts? Yes. Constitution of criminal courts என்ற section சொல்லியிருக்கு. Yes. சத்தமா சொல்லுங்க. It is wrong also, no issues. Right? Very good. Section 6. Section 6 of criminal procedure deals with the constitution of criminal courts. So, which is the lowest court? Judicial magistrate of the first court. Then comes the chief judicial magistrate court. Then comes the assistant sessions court. Then principal sessions court. Then principal sessions and additional sessions court. Then district court and sessions court. Then high court and supreme court. So this is the hierarchy of or the constitution of criminal courts. Likewise, நம்ம civil suitல lowest courtல தான் suit file பண்றோம் as per section 15 of CPC ல படிச்ச மாதிரி even while like special provision when it is unless and until it is mentioned in the special provision like NDPS Act and the court then normally file பண்ணும். Or else first you have to file a petition or file a complaint or file the FIR before the lowest court, that is the chief judicial magistrate of the first class. Clear? But once உங்களுக்கு அந்த submit பண்றது send பண்ற provisions எல்லாம் தெரியுமா? Once a case comes before the court, if the court does not have the power or to try the suit, then it will submit to the concerned courts, whether it is to the CJM or to this or to the district court. So, in the court, in the case try பண்றதுக்கு right இருக்கா? So, right in jurisdiction இருக்கா? Power இருக்கான்னு சொல்றது என்ன section? First of all, we will deal with which court has power to try a case in the section of சொல்றது. That is with regard to the powers of criminal courts is then under which section of CRPC. Guys, please settle down. Section at section 9. I'm asking under CRPs. It depends upon the power of the court as well as the sentencing power of each court. Section 26 and 28 of CRPC படிச்சுக்கோங்க because under 26 it is mentioned that which all court has the power to try what are specific offences. For example, the High Court and the District Court has the power to try any offences under IPC. Any offences, irrespective of its whether. Let's please settle down. As per section 26 of CRPC, ma'am, continue. As per section 26 of CRPC, it says about the power wherein the High Court as well as the Court of Sessions has a right to try any any case or any offences which is under the IPC. Other than that, what is mentioned in the first schedule of the CRPC? First schedule I mentioned, but they have given a table, right? Of what is the format? Case another. 1 second. Let me get the. Yes. IPC section provisions for then what is this offences and what is the punishment concern, whether it is cognizable or non-cognizable, whether it is bailable or non-bailable, and then comes which court the case can be tried. Whether it is judicial magistrate of first class or whether it is by the Court of Sessions or whatever it is or by the High Court, it is being mentioned as with regard to IPC mentioned in the first schedule. I hope you people know this, right? And under section 28 of CRPC says about the sentencing power of each court. Depending upon the sentencing power and also jurisdiction of where the when and whether the matter occurred, the court will see whether it has a right to try the case or not. First of all, could anyone answer me the sentencing power of High Court? Answer me. Any offences, and no, there is no restriction with regard to the sentencing power. But High Court may pass any sentence which is authorized by law. This is what is mentioned in section 28. That is, it has a right to try any offences which is mentioned under the law. The law maybe depends not just IPC, any law. Any offence the High Court has a right to try the suit. Sorry, try the case. Then comes what about with regard to sessions court and additional sessions court? Yes? With the confirmation of the High Court under section confirmation under section correct 366. So what with regard to the power of district court, that is the sessions court and additional sessions court, it has also right to try any give sentences, but even death sentences also can be given and only with the confirmation of the High Court under section 366 of CRPC. Then what about assistant sessions judge? Then yes, assistant sessions judge court has a right to sentence other than death sentence and also punishment which does not exceed 10 years. So up to 10 years and death sentence கொடுக்க முடியாது. Up to 10 years வரை assistant sessions judge has the right to right to give sentence. Clear? High court, district court, that is a sessions court, and assistant sessions court is done. Then comes what? CJ, Chief Judicial Magistrate Court. So what is the sentencing power of up to 7 years? 5 not exceeding? Fine சொல்லுதா? Fine சொல்லுதா? Except death sentences up to not exceeding 7 years. Okay. And what about Chief Magistrate of the first class? Years and why only one person is participating? What about the others? Years and up to fine up to 10,000 rupees. Then judicial magistrate of the second class, 1 year and 5,000 rupees. So in the list of 5 courts, second magistrate of second class, first class, assistant session judge, district judge, and high court. In the courts, the court has the right of forfeiture of property, or tell me which court doesn't have the right to forfeiture of property. There are 5 modes of punishment, right? And the one of the mode is forfeiture of property. Idilla endha court ku forfeiture of property ku right illa. Judicial magistrate, second class, and CJM ku irukku. Irukka? Tell me guys. Irukka? CJM ku irukka? Yes na forfeiture பண்ணலாமா forfeiture பண்ண முடியாது? பண்ணலாம். Yes, it can. Because why? Because the judicial magistrate of the first class and second class specifica only up to 3 years and 10,000 rupees, only up to 1 year and 5,000 rupees. That offense is being specific. The sentencing power is being specific. In all of the 3 other judge codes, it is said that all any offenses except idu moonu da. Up to 7 years and up to 7 years, up to 10 years, up to it is inferred. People have to infer that those other codes also have the right of forfeiture of property. Clear? Is it clear? So hierarchy பார்த்தோம். So as like from civil code suitல பார்த்த மாதிரி தான் hierarchy like from what you say sub civil judge அப்படி பார்த்த மாதிரி judicial magistrate for chief judicial magistrate, judicial magistrate of the first class, chief judicial magistrate, assistant sessions judge, then sessions judge, and also high court. So this is the hierarchy. Now இன்னி நம்ம ஒரு கேஸ்க்கு இன்னி என்னெல்லாம் இம்பார்ட்டன்ட் நம்ம சிவில் கோர்ட்ல பார்த்த மாதிரி இன்னி அந்த கோர்ட்டுக்கு ட்ரை பண்ண ஜூரிஸ்டிக்ஷன் இருக்கா இல்லையா? Under which provision of CRPC deals? Yes, these are very important. Those who want to talk and doesn't want to attend my class, please leave the hall, please. எங்க class attend பண்ணணும்னு எனக்கு யாதொரு நிர்பந்தம் இல்லை. I don't have any kind of thing. Please those who want to leave and talk, please leave my class. கேக்குறீங்கன்னா பேசாம உட்காந்து கேளு, இல்லைன்னா தயவு செஞ்சு வெளியே போயிரு. It's an humble request from my part. Those who want to talk, please leave the class. So tell me, what is the jurisdiction provision with regard to jurisdiction of trying criminal case? மட்டும் சத்தம் வராத யாருக்கு? 177 to 189. What is section 177? It's a general statement, whereas from 178 to 189 is all specific things. What does section 177 says about Jana? Yes. Section 177 is a general statement. Okay. And from other things, all it's been specific. இன்ன காரியத்துக்கு இன்ன offense நடந்ததுன்னா இன்ன கோர்ட்டுக்கு jurisdiction இருக்குன்னு சொல்றாங்க. It is specific. What is a general statement? Every offense shall ordinarily be inquired and tried by the court within whose local jurisdiction the offense was committed. But this is the court. In the court jurisdiction or offense நடந்ததுன்னா and the court has a right to try and has a right to inquire and try the offense within whose jurisdiction the offense was committed. Rest is all exceptions. Exceptions means it means specific. And please go and read the rest of the sections from section 177 to 189. Clear? So, is it clear with regard to the power of constitution of the court? Constitution of the court clear done. Hierarchy of the court, sentencing power of the court, and also jurisdiction of the court. Clear? So this is a basic thing that you need to know before starting or before looking into criminal matter. Now, in order to institute or in order to start a trial or a criminal case, there are two ways. First thing is by instituting an FIR, by filing an FIR. What is an FIR? First information report with regard to what? Yes. Regard to the offense that has happened. Okay. So, FIR vadi irukku. Another way is like filing private complaint. What is the procedure with regard to filing an FIR? What all you have to see that it has been compiled. First is section 154 with regard to cognizable offense. Cognizable offense na? Can the police arrest without warrant or with warrant? Then section 155 with regard to non-cognizable offense. So when a person comes before the police station, to whom he has to report to, that he has to file an FIR. Officer in charge. Who is an officer in charge or SHO? SHO என்ன ரேங்க்ல இருக்கிறவங்க? SHO means circle inspector. CR. Okay. So, what is the format in which he has to give? It should be oral or it should be written or it could be both. Both oral or written. If it is an oral, what has to be looked into? Yes. It shall be reduced in writing. That is what the law says. It must be. That means not may. It shall be reduced in writing. If it is an oral complaint, you want to lodge an FIR orally, then it has to be first. If it is given orally, then it shall be reduced in writing. Then, and it has to be signed by the person giving the FIR, and those things have to be entered in the book that is kept for called the general diary. Clear? So far as it's clear. And if it is a woman, a person is coming to lodge an FIR, it should make sure that it has to be reduced down by the woman officer. What if a woman officer is not there in the police station? She has gone out for some other official purpose. Then, ஒரு woman police officer தான் ஒரு maybe ஒரு rape victim has come and she is there to lodge an FIR. It is mandatory that he should be taken down by a woman police officer. What if she is not present in the police station? Then who should she wait for the woman police officer to come, or what has to be done? That is there, and that is for especially for rape victims, and that is 2018 amendment that is there, that he has to go to the norm. Generally speaking, if a woman has coming to the police officer to lodge a complaint or FIR, simple, very simple, logically. Another woman police இல்ல அந்த ஆஃபீஸ் ஸ்டேஷன்ல அவங்க என்னமோ ஒபிஷியலி வெளியே போயிருக்காங்க. She would be coming. It is very simple. I'll read. அந்த ப்ரொவிஷன் மட்டும் சொல்றேன், அது நீங்க எக்ஸ்பிளைன் பண்ணணும். Such information shall be recorded by a woman police officer or any woman officer. What does that mean? Any woman officer. Huh? Any public servant. அவ்வளவுதான். Any woman public servant. Any தஹசில்தாரோ வில்லேஜ் ஆஃபீஸரோ யாராவது பக்கத்துல இருக்கிற ஏதாவது உமன் ஆஃபீஸரை வந்து ஸ்டேட்மெண்ட் வாங்க சொல்லுவாங்க. Could be any public servant. It could be any woman public servant. அவங்கள என்னமா ரேங்க்ல என்னமா ஆத்திருப்பாங்க, அப்படி இல்லாம இருக்க மாட்டாங்க. இங்க போலீஸ் ஸ்டேஷன்ல இருக்காங்க, ஆனா டியூட்டிக்குனால வெளியே போயிட்டாங்க. எல்லா ஸ்டேஷனரும் woman office has to be there, right? So is it clear? And also with regard to the specified offense like 354A, 354B, C, then 376A, 376AB, other provisions எல்லாம் இருக்கு. 2018 amendmentல வந்த provisions எல்லாம் இருக்குல்ல. If a person is coming forward to lodge a complaint FIR with regard to that, those things has to be taken at the residence of the victim or the person giving the complaint. It should be videographed, and also it should be videographed, and the statement of the person it must be recorded by the judicial magistrate as per section 164 clause 5A and clause A of CRPC. Clear? Is it clear? And a copy of the said FIR or complaint has to be given to the person who's lodging the complaint. Now, what if the police or the officer in charge of the police station refrains from taking the complaint? What is the remedy available to the other person? What does the clause 3 says? Superintendent of police. So you can further give the complaint before the superintendent of police or DYSP, whoever concerned. And what if he also refrains to continue with the proceedings? Then only you have the right to filing the private complaint. So before filing a private complaint, as per section 154, that is with regard to cognizable offense, you with the copy or the receipt that they have given, along with that we file the private complaint. Here, rest of them will take in the next class in detail. Before that, participating for Moot competition is the last day by 11:59. You need to submit your memorial, both the respondent and all the format and code is clear and is given in the regulations. Now, the site or the email ID is also given below. That is Dr. Ambedkar Global Law Institute at gmail.com. Clear? நீங்க அந்த mail அனுப்பும்போது subject you have to mention your team code. Team code. Team code. memorial, I see code A, B, C, D, whatever this has to be mentioned, and also it must be in PDF format. Here, by 11:59 p.m., we need to have the soft copy, and there will be consequences. So make sure whatever you have completed and the hard copies have to be submitted by 3rd April. Five sets of hard copies has to be 5 analysts and 5 respondents has to be submitted by 4 p.m. 3rd April, 4 p.m. The cover page has to be blue for the analysts and for the respondents. And team code has to be mentioned on the cover page on the website or wherever it's convenient for you, but it must be visibly reviewed. Here, anything else? Any doubts? So if you're not able to submit this message, should be PDF format and it has to be the subject of the mail has to be with your team code.
That today afternoon you will have police station or your post as everyone will have police stations by 2 these are the police stations. Each other here. Here, 4 o'clock he will go. Class will come back. Class will be here. He will be giving class morning sessions of honors and also class works. General class will be off. So, so till now we have seen this compared to the subject professional ethics. You won't have you will not have internal examination for professional ethics. three records. There were three records for the ADR and drafting phase. Three records. Internal security contained. That also it will be only affecting to be continually done. No worries about that. That's the only thing that I can keep it out. That also drafting period contains code in that area. When we make it very clear, please listen, especially last bit, please listen. When we are giving you materials to write, go to the material maps first. Let's go through the material method, what you are giving. Don't complain like there are lots of pages left. That happens, you will not sign. That's not faculty, you will not sign your work. If it is not signed, you will use your you will not be allowed to copy. Am I clear? Go to the material first. What are materials are given to you? Go through those materials. Whether it be technical compliance, whether it be Moot code, or whether it be area. Okay. First of all, let's go in. So A, whatever materials will be provided for I need materials and ambiguous statement of the idea. So in these materials, like Moot code material will contain three Moot code participations. Those are role play Moot code participations. Like what we have done here, Moot code. Likewise, three Moot code problems will be there. Which again you have to write here. That is your Moot code. After that, you will have code visits. Either or visit or observation. It is code visit or observation. You have observed in the code, you will be writing that inside that again. So that also we need voice written statement. Everything civil side. First, part A civil side. Next part C, part B, criminal side. Finish. Then next part. There are so three parts. Last part. Last part will be chamber visit. That is the chamber, aggregate chamber of office where we have visited. Now, what is that up to? In that you will be writing regarding what are we have observed in the chamber, your senior office. You might so certain details given in your chamber diary that you have to write it in that record. Again, continue. Okay, so you need to write down. So what you need to do is first what are materials we have given to you. Please go through those materials. Then I have certificate last bench. Please listen very carefully. Don't call me afterwards. Sir, என்ன பண்ணணும் sir? No. Please listen. ஒரே ஒரு காரியம் பண்ணா போதும். What is it? Apply your mind with it. When moments is apply. Okay. See what should be and stuff. Video people asking me either video or video. So that part so Moot code will contain parts. Moot code 1, 2, 3. First part, second part, the chamber visitor, third part, code observation. Moot code is over. So take your Moot code record, see the calculate number of pages. Page numbers in the record. Then see the material. How many number exceptions are there. According to this, you short you reduce your handwriting. Your handwriting is small to enlarge it, right? Make it large so that page number is sufficient. Yes, sir. Then drafting. Drafting also certain items which particulars mentioned in the drafting will also repeat in record. That is a good code record. Along with the repeat out. Don't worry about that. So I have already looked at this here. Don't ask such questions. Drafting also. Drafting material which we are giving you is a very important material. Okay. അതുപോലെ advancing എന്ന് പറഞ്ഞ ഒരു is there. It is very useful for it. If you are starting studying lawyers, you can go through those advanced writings and read how to write a deed, how to write a partition deed, how a will agreements, etc. are there. All things are there in that. So go through those. Go through those manuals. It's very useful for you. Somebody may approach you in order to write a rental agreement. You might say, I don't. Take your material, change the name and give it. Okay, so that will be very useful for you. Drafting also similar side of the sides also. Drafting. Then comes area. As because is making area, you might have an idea what area is. So regarding that also, we are providing the area. We have introduced note communication scenes. Why? Have changed this time. Have changed your material. The material which was given to your seniors mismatched with others. Okay. First time, don't communicate with your seniors for the purpose of writing your record. Those materials are not the same materials given to you now. You have changed it. Media earlier we did not have anything regarding to role play. Now we have introduced role play. Actually, you should have role play. You will act as a both sides as an arbitrator. How can arbitrate the arbitrator matter? You don't have time for that. That is why we use it. That is why we have introduced only one which also only you have given them. Okay, so negotiation again, negotiation again, mediation. How a mediation agreement would look like? Have you seen a mediation agreement? Have you seen a mediation agreement yet? No. Have you seen an arbitration agreement? Does an arbitration agreement should exist apart from a contract entered between parties or inside a contract arbitration agreement exist? Second, need not necessarily that arbitration agreement itself sentence is necessary. If not any dispute arises between the parties may approach the small arbitrator may be dashed. According to the consent of both the parties, they introduce one introduced. That is when the regard arbitration agreement is there. Apart from the contract itself, we have given an arbitration agreement. Then we have yes, arbitration award. Arbitration award is also there. Arbitration award. Mediation is not an award, it's an agreement. Arbitration is an award. Award is considered the arbitrator. So the arbitration is by a judge. names of the parties in the materials is not given. I think the mark has X, Y, Z. Okay, because those are real cases. Actually, these should be done by students. We have to feel. I believe that the first should be. So we are thinking about every materials. Both of those materials, as I told you again, I'm repeating, area, make the method, see the number of pages, count the number of pages for the materials, accordingly you write it. We have given anything unnecessary. Earlier we had this act itself, municipal model rules itself we had in your seniors, but we have given those. So there is nothing unnecessary in your record. Each and everything is important. Apply your mind. No, realize what you're writing. Yeah. Realize what you're writing. Yeah. Understand? So realize what you're writing. So what we need to understand is that these materials which we have given you and whatever you are writing in your record, that will help you when you write come to the view. Because lucky, yesterday we have taken that signature and we have given it to the university. The university decides to conduct the examination before 8:15. We expect that between 6 to 12 there will be Viva. Viva is important base. That will be the final day of you in your audience as a student. Otherwise, you will be free. Okay, so that Viva over papers will ask you questions with regard to these materials also. Okay, so whatever materials are given to you, go through the commission, appointment of a commissioner, which rule, which order, what is the summer, what is the order, which is the rule, according to which the CPC, commission is appointed. In the petition itself, the very important thing. What is the commission's under CPC to find a written statement, voice, etc. Everything, go through that. Understand what you are writing. These functions and we are there by don't worry. That is clear. And professional ethics is a very easy subject. Just write your exams. Nothing else. And Viva is also few questions will be asked. Repeated question every day. Viva board member will ask me. What are the 7 answers for this? Almost every day that will be asked. Viva is 7 answers for this. What was the 8th introduced? Who introduced that? These are the simple questions that is none of the questions will be asked. But not any other questions will be asked. But other than that, other panel members will be asking anything. 7 answers for this. There are other questions also. And both will be also provided. Here, every time they are those proofreading. Luckily, the management is providing materials general terminology of law, what is what is the comment, etc. They be asked, and that also will be provided. Provided you can't study, but unfortunately, you may ask you who is the principal of this man is he will be there to decide. Some of the people will be there to find out that he is the principal. Many of you, please at least know where you are, what is the name of your college. So many of you are you don't know. Professional ethics again, internal question papers, 11. You don't have internals. You are only external. They will be giving you that question bank. Question bank will be given to you. Go through those question banks. You will definitely pass for professional ethics. I will get it. Okay. Face for professional ethics. Where are you going? Right? You study those question papers, at least when 5 question paper is organized by at least minimum 5, then it's all repeated. Every time is a repeated. Therefore, with regard to part C also, part B and part A, what are the other questions enrollment of certificates, 7 acts of efficacy, and what are misconducts. Only doubt is with regard to professional misconduct. The evidence for professional misconducts are different. Why? Because it is not defined or mentioned under the code. For which we have case laws. That is the only problem. For this, you have to rely on mining. Good. There's a book written by many professionals. It's a very small in which part C question. Go to the part, last part of this after the subject are mining, mining, yes, there are lots of books. Professor, my name is I'm sure that the next day there in our library. Most of you guys purchase it and others can take a question. Okay. So deal with those part that last part of the vaccines. Okay. So till now we have seen discovery proceedings. We have seen till section 40. We have to see section 42. Powers of the discovery committee under section 42. A may be a question. Does it possess the problem which is possessed by the civil courts under CPC? Yes. Discovery committee possesses all the authority and powers of the civil code under the civil procedure code. What is the year of CPC? 1908. So it will have the power to summon has the power to summon the authority, examining on both using certain documents before the court, requesting the party to produce a document, receiving evidence, which are not powers of the civil code. You know, so all these powers regarding receiving, requesting public documents, issuing commission. Commission, appointment of a commission, order 26, it is full 9,000 order 26, all those things are easily available. It is there. The legal study, we have to go to court, we have to go to advocates office and collect the individually, and we have to spend money for getting all those steps. We pay only once and everything so after the disciplinary committee, we said that it is possessing the authority power of the civil judge. The disciplinary committee does not have an authority to call an officer of the court for purpose of examination. Prior request is sent to the concerned high court to whom he is subordinate. So if the high court allows, then that court officer may be or he has to or appear before the disciplinary. Otherwise, no. Likewise, also any officer of a revenue court also, not he has no authority. District court, sorry, the disciplinary committee has no authority to summon the court officer of the revenue court. Unless until the prior authority is received from the concerned government. So if he is a subordinate officer of the high court, then the prior authority or prior official of the high court is necessary. When he is a revenue officer, the officer of the revenue court, concerned government has been published. With this, we will complete section 42 of the Ethics Act. Now we will have to see the content or mode of content of lawyers. We have seen the rights of advocates. We will go through the duties of advocates. Again comes to part B. Part B questions. What are the rights of advocates? The right to practice is also contained in the body of Article 91 clause G of the Indian Constitution. Is it a fundamental right? These questions will be asked. Which we have covered. Now the next topic is duties of advocate. What are the duties of advocate? Where are the duties of advocate listed or written? Please refer to chapter 2 for not in chapter 2. Over 6, part 6, chapter 2, part 6, or the Bar Council of India rules. Bar Council of India rules are the NES. According to which section is Bar Council of India making rules? Is Bar Council of India having any authority to make rules? Yes. The question is section 49 1C. Section 49 1 subclause C. Small c. The provisions of section 49 subclause C provides gives authority to Bar Council of India to create rules or make rules with regard to what? To lay down certain standards of conduct and etiquette to lawyers. Standard of conduct, how they should behave in the society, has been laid down, or the Bar Council of India is given power to make certain rules to how an advocate should behave, or what should be the conduct of an advocate. Now, it is laid down, thus it is laid down by chapter 2, part 6 of Bar Council of India, where you can see all these questions. We have one there are different duties which are vested in these rules. Duty towards the society, duty towards the country, not the first duty to the country. Duty towards the country. Now, in duty towards country, not down A, there are what are the duties towards the countries which we have to do? They are he needs to endeavor to make laws, suitable laws to the lawyer. If there is given down there are certain laws which are not suitable to the society, what can a lawyer do? He can approach the concerned court. Like, as previously Professor came here and delivered a lecture, and he addressed the students there. Whenever a law is being introduced before the assembly, the government is giving us equal opportunity to reform it by writing a letter from paying your message to website. Nobody does it. Nobody does it. That is the way by which you can communicate to the concerned government for a reformation. Maybe a bill and that bill is affecting some interest, you can point it out. Or if that bill is not particularly addressing some issue again, you can point it out. So it is your duty vested. Now, guardian liberty, he is the guardian. He is the guardian of liberty and freedom of people. You guard. B. Next one. Duty to guard liberty. Duty to guard freedom. Guard liberty and freedom of people. Guard liberty and freedom of people. Now, when I say duty to guard liberty and freedom of people, another thing connected to this is nothing other than fundamental rights. So, next duty, protect fundamental rights. So, he is vested with the duty to protect fundamental rights. Protect the fundamental rights, can you say as another right? Human rights. Fundamental rights, human rights. Where are these vested? Where are these rights vested with or where can we find these rights? And these have been protecting the constitution. So there are right rights. So these have a duty to protect fundamental rights, human rights, and the constitution. Okay. The constitution. He is also vested. Next one. Next. He is vested with the duty to uphold integrity and unity of the nation. Simply like uphold unity and of the nation. Unity and integrity of the nation. So next one, you can uphold these rights whenever there is a respected court existing in your country. Whenever there is a court which is named known as court, which is justice, that gives us justice. So it is the duty of a lawyer to always respect law and respect the court. If you, who is a lawyer or advocate, do not respect the court, can we expect a common man to respect the court? No. So at all time we need to give awareness to whom? To the general people, to the people of one country, for what? To respect the court, to respect the law, and the decision is rendered by the court. If the law decision is rendered against you, what is the option available to you? It is not to speak against the decision. That the decision rendered by the court is not valuable and should not be a real decision. But what you can do is, by what appeal, so educate people with regard to what? The law, educate people to respect law, to respect the court, and to respect its decision. Respect what? The law, the court, and its decision. And its decision. Which duties there are the whole world will be പഠിക്കണം വൈവായി ഇപ്പൊ എല്ലാமே going on. Shubhamast. Already problems are said. Because it's supposed to take subject didn't get a generally, but we are giving it external what will be needed to the other people. That's it. Not start like so after giving records, as I told you, go through कोई हाईकोर्ट में
Huh? But what to do? Yeah, please. Yes. Please settle down. Yeah, please come inside. Please come inside. Yeah, நீங்க போலியா போலீஸ் ஸ்டேஷனுக்கு ஆஃப்டர்நூன் ரைட் ரைட் now so today we are going to see another form of alternate dispute resolution, that is negotiation, right? Yeah, please listen, please. Once if you come into the class, listen something, at least listen something, right? Now negotiation means it is another form of alternate dispute resolution. It is very much in contrast to arbitration, right? Arbitration enna nadakum, you are going before the arbitrator getting the award. Here who is adjudicating your dispute? Arbitrator is adjudicating your dispute. That means he will assess all your claims and he will possess an award, right? That award is binding and final on you. But in negotiation, the third party will be there. What he is going to do is he will make two persons sit. அவன் என்ன பண்ணுவான்னா ரெண்டு பேரை உட்கார வைப்பான். உட்கார வச்சு he never adjudicates the dispute of these persons. He will make these two persons come to an understanding by resolving the disputes. He will simply say, this is your problem, this is your problem, right? Now you both sit, I will assist you in helping to coming to a conclusion, right? Now he never adjudicates your dispute. Remember, in arbitration award is passed, but here he never adjudicates your dispute. Simply he will help you to arrive at a decision. Once decision has been arrived, so that both the parties will enter into an agreement, right? Our disputes are resolved, right? Here parties will be there, negotiator will be there. That means he is not adjudicating like in arbitration. He will help you in an informal way to get a possible solution, right? Now in fact this negotiation has been recognized in Arbitration and Conciliation Act also. Simply இது வந்து ஒரு பஞ்சாயத்து கிடையாது, நீ வந்து உட்காரு ஒரு டெசிஷன் பண்ணலாம்னு சொல்லி. Again this negotiation is based on two theories. So first one is principled negotiation. Principled negotiation. If anybody knows statistics, certain permutations and combinations will be there. Have you heard about permutation combinations? Right. ஒரு டைஸ் போட்டா எத்தனை வாட்டி 2 வரும் எத்தனை வாட்டி 3 வரும்னு சொல்லி இருக்கும். இங்க நெகோசியேஷன்ல கூட straight away he don't make you to sit and solve your problem. There is a scientific rationale for arriving at a decision. Scientific theories இருக்கும் இதுல கூட. For example, transaction analysis, economic analysis. That means they are taking the help of these theories. This is the problem. This is the outcome. So they will, with the help of some test, என்ன சொல்லுவான்னா chi-square test ன்னு சொல்லுவோம் ஸ்டாட்டிஸ்டிக்ஸ்ல. They will apply some techniques. இப்போ இது ப்ராப்ளம் இருந்ததுன்னு நினைச்சுக்கோங்களேன், இந்த ப்ராப்ளம்க்கு இது அவுட்கம் வரும், இந்த ப்ராப்ளம்க்கு இது அவுட்கம் வரும். இதெல்லாம் எப்படி டெஸ்ட் பண்ணுவான்னா ஒரு எக்கனாமிக் பேசிஸ்ல சர்டைன் டெஸ்ட் எல்லாம் இருக்கும். அதெல்லாம் பேஸ் பண்ணி this is the solution you are going to get. For example, you know hypothesis. என்ன hypothesis அண்ணா? What is meant by hypothesis? என்ன hypothesis அண்ணா? End result. End result is hypothesis. When you start a project, அந்த ப்ராஜெக்ட் நீங்க இன்னும் பண்ணவே இல்லை, இது பண்ணா ரிசல்ட் இது இருக்கும்னு சொல்லி ஃபர்ஸ்ட் ரிசல்ட் நீங்க கொடுப்பாங்க. Then you are going to work on those hypotheses. For example, one person has committed an offense, crime. இப்போ one person has stabbed another person. இப்போ என்ன பண்ணா போலீஸ் have arrested. He has been produced before the court. Now what the public prosecutor is telling, he did the crime. அவன் தப்பு பண்ணா. ரைட். அவன் தப்பு பண்ணான்றது என்னது? end result. End result. Now what happens? அவன் தப்பு பண்ணா நீ கோர்ட் என்ன சொல்லும்? அவன் தப்பு பண்ணா நீங்க சொல்லிருக்க, you prove. End result is he did the mistake. Then what you have to do is you have to build all the evidences like this. அந்த எவிடன்சஸ் எல்லாம் பில்ட் பண்ணி அவன் தான் தப்பு பண்ணான்னு சொல்லி அவுட்கம் அது end result. டிஃபென்ஸ் லாயர் என்ன பண்ணுவான்? அவன் தப்பு பண்ணல. ரைட். தட் இஸ் தி end result. Then court asks, prove it. That is, first you are putting end result. இது பண்ணா இது வரலான்னு சொல்லி ஒரு ரிசல்ட் வச்சு அத நீங்க ப்ரூவ் பண்ணணும். So like in negotiations also, certain theories have been applied to get the end result. Why? Both should be happy. It is nothing but win-win situation. I should win, you should win. ஒரு பார்ட்டி வந்து நஷ்டம் வந்து இன்னொரு பார்ட்டிக்கு லாபம் வரக்கூடாது. ரெண்டு பார்ட்டிக்கு என்ன வரணும்? லாபம் வரணும். That is known as win-win situation. So first one is principled negotiation. Theories of negotiation. First one is principled negotiation. This negotiation principle has been developed by Harvard negotiation project. Harvard University இருக்கு இல்லையா? So they have the project has been developed by Harvard negotiation project. They have developed this technique, theory of negotiation. It is known as principled negotiation. Now in this இது எது மேல பேஸ் ஆச்சுன்னா there is one book is there. That book name is Getting to Yes. Getting to Yes. YES. Getting to Yes. That means you are taking both the parties with an acceptable solution. So here what happens is, here both the parties, they will present their demands. He will also present his demands. He will also present his demands. At one point of time, they will reach a conclusion. I am having this demand. I am having this demand. Now at one point ஏதோ ஒரு பாயிண்ட்ல ரெண்டு பேரும் ஒத்து போவா இல்லையா, ஏதோ one pointல, then negotiation success. So they will apply this principle negotiation. Second theory is negotiation analysis. Negotiation analysis. Now this negotiation analysis is similar to economic analysis. யாராவது எக்கனாமிக்ஸ் படிச்சிருந்தா அது உள்ள கேம் தியரின்னு சொல்லி ஒரு ஃபார்முலா கேம் தியரின்னு சொல்லி. So they will apply this game theory and they will arrive at a possible conclusion. These are the two theories. Now going into steps of negotiation. There are 5 steps of negotiation. ஒரு negotiation பண்ணணும், negotiation பண்ணி results வரணும்னா normally negotiator will follow 5 steps. So first step is preparation and planning. The first step is preparation and planning. Right. Now every negotiator, he will ask the parties to prepare their demands. What are your demands? What you expect from the negotiation? உனக்கு என்ன வேணும், உன் ப்ராப்ளம் என்னன்னு சொல்லி first you write. Again he will ask the other party also, what are your demands? You put it in the paper. First stage is preparation and planning. Right. Now once preparation and planning has been done, then they will go to second step. Second step enna, definition of ground rules. Definition of ground rules. Right. Now எல்லாத்துக்குமே ஒரு ground rules இருக்கும். Rules define how the parties are going to arrive at the decision. உனக்கும் நியாயம் நடக்கணும், இவனுக்கும் நியாயம் நடக்கணும். For example, if you want to play cricket, there are certain rules. If you want to play football, there are certain rules. If you bypass the rules, what happens? Then penalty will come. Here also, when you are going to arrive at the decision, making the parties to come to a what is called one conclusion, certain rules will be there. Rules means is that person has to obey the orders, this person has to obey. In the rules alla follow pannano. That is known as definition of ground rules. Once you prepare and plan, second step is ground rules. These are the rules on which I am going to judge you. One problem idu, one problem idu. The rules prakaram na enna pannuvenna, naan vandu negotiate பண்ணுவேன். Ultimately negotiation fails, you have your own remedy. Negotiation fail ஆச்சுன்னா என்ன ஆகும் திருப்பியும், you can go for arbitration, you can go for your legal remedies. I will try to negotiate, I will try to solve the problem. Third step is clarification and justification. Third step is clarification and justification. Right. Now the negotiator will clarify his ideas on what things he are going to analyze your problems, and he will justify the reasons for the same. Remember, in negotiation also, the main crux is win-win situation. Both parties should win. That is the main criteria for negotiation. Fourth step is bargaining and problem solving. Bargaining and problem solving. This is the fourth step involved in negotiation. Bargaining and problem solving. Bargaining means he will make and sit. He will ask both the parties, let's come to a conclusion on these lines. So, is this solution amicable for you? Is this solution amicable for you? இது இந்த லைன் மேல போனா நம்மளுக்கு ரெண்டு பேருக்கும் சமநியாயம் கிடைக்கும். So let's bargain. You go to the shop. If you want to purchase a product, if the shopkeeper tells 10 rupees, you say 8 rupees. Then what shopkeeper tells? No, no, you pay 9 rupees. Then you will tell, I will pay 8.5 rupees. Then what happens? Negotiated. Negotiated sale. இதே மாதிரி இங்க கூட இருக்கும். இது உனக்கு கொடுக்கறேன். அவன் என்ன சொல்வான்? முடியாது ஒண்ணுவான். ஓகே, நீ என்ன கொடுக்கற? இது கொடுப்பேன். இது உனக்கு acceptable-ஆ? ஓகே. Then they will bargain the things and subsequently they will reach an amicable situation. Last one is closure. Closure means closing the negotiation and implementation. This is the fifth step in negotiation, closure and implementation. So let's recapitulate 5 steps in negotiation: preparation and planning, definition of ground rules, clarification and justification, bargaining and problem solving, closure and implementation. You are following these 5 steps. Now every endeavor has to solve the problem. இப்போ அந்த ப்ராப்ளம்ல சிலது இருக்கும். அது என்ன சொல்லுவான்னா 4 C's of negotiation. C, capital C. Every negotiation has got 4 C. First C is common interest. First C is common interest. ரெண்டு பேருக்குமே அந்த ப்ராப்ளம்ல ஒரு காமன் இன்ட்ரெஸ்ட் இருக்கும். Next C is conflicting interest. Conflicting interest. That means every interest goes against another person. காமனா ஒன்னு இருக்கும், எல்லாருக்குமே பொதுவா ஒன்னு இருக்கும். கான்ஃபிளிக்டிங்கும் இருக்கும். இது எனக்கு வேணும், எனக்கு வேண்டான்னு சொல்லி. மூணாவது என்ன? காம்ப்ரமைஸ். Certain compromise will be there. At this point of time, both the parties will compromise. Last one is condition. What are the conditions for entering into a consensual agreement? Inga nothing but add idam and solva. Identity of minds. Add idam. Both the parties should reach add idam so that they can find an amicable solution. These are the 4 C's that has been recognized in the negotiation. First one is common interest. Second one is conflicting interest, compromise and conditions. Right? Next stage is 5 main types of negotiation styles. There are 5 main types of negotiation styles. These are the 5 main types. ஒன்னு வந்து ரெண்டு பேர் accept பண்ணலாம். Sometimes you make one person to accept for the other person's request. So first one is compete. COMPETE. First style is compete. First negotiation style. The meaning என்னன்னா I win, you lose. Compete. I win, you lose. This is one stage of negotiation style. Compete means I am competing with you. I want to win. Please, you lose. Right. Second style is accommodate. Accommodate and enna? Nanu ottu poren. I lose, you win. I lose, you win. This is accommodate. Third style is avoid. Avoid. I lose, you lose. Yanakku venda, unakku venda. I lose, you lose. Normally, we will follow this type of negotiation. அவ்வளவுதானே? வந்தா எனக்கு வரணும், இல்லைன்னா உனக்கு வரக்கூடாது, உனக்கு வரக்கூடாது, நானும் எனக்கும் வேண்டாம், உனக்கும் வேண்டாம். ஸோ உங்களெல்லாம் நெகோசியேட்டரா வச்சா you will follow avoid. I lose, you lose. அவ்வளவுதானே? நெகோசியேஷன் புரிஞ்சுன்னு இருக்கா? புரியல? புரியுதா? புரிஞ்சாலும் ஒன்றும் பண்ண முடியாது, புரியலன்னாலும் ஒன்றும் பண்ண முடியாது. ரைட்? யூ அண்டர்ஸ்டாண்ட்? யூனோ, எனக்கு இங்கிலீஷ் எப்படி வந்து தெரியுமா? நான் இங்கிலீஷ் நல்லா பேசுறேன்டா, சூப்பரா பேசுறேன்டா. யூனோ வை ஐ காட் இங்கிலீஷ்? ஐ ஸ்டடி 10th கிளாஸ் வரைக்கும் தெலுங்கு மீடியம். நான் தெலுங்கு மீடியம். ஐ ஜாயின்ட் இன் ஒன் ஸ்கூல், சென்ட்ரல் ஸ்கூல் ஜாயின் ஆனேன். அங்க வந்து ஒரு இங்கிலீஷ் பொண்ணு இருக்கா. நோ நோ, ஐ வில் டெல் யூ. யா ப்ளீஸ். நோ நோ, ஃபார் எவ்ரிதிங் தேர் இஸ் த ரீசன். She speaks only in English, and if you want to convey your ideas, only English தான் இருக்கும். எதாவது சொல்லணும்னா இங்கிலீஷ் தான் சொல்லணும், அப்பதான் புரியும். எல்லாரும் இங்கிலீஷ் பசங்க எல்லாம் இங்கிலீஷ் பேசுவா, எனக்கு இங்கிலீஷ் வராது. நான் என்ன பண்ணேன், தினம் நியூஸ் பேப்பர் எடுத்து புக்கில் வச்சு இங்கிலீஷ் வேர்ட்ஸ் எல்லாம் எழுதி 2 வருஷம் கஷ்டப்பட்டேன். இங்கிலீஷ் வந்தது எனக்கு. இப்ப பேசலான்னா அந்த பொண்ணு இல்லை. லாஸ்ட்டுக்கு எனக்கு என்ன இருக்கு, இங்கிலீஷ் தான் மிச்சம். அண்டர்ஸ்டாண்ட்? நோ. I will see only positive things in the life. You understand? லாஸ்ட்ல இங்கிலீஷ் வந்து நல்லா இங்கிலீஷ் வந்து போட்டோம், அந்த பொண்ணு இல்லாத போனா போட்டோம், எனக்கு இங்கிலீஷ் நல்லா வந்தது. ரைட்? நோ, திஸ் இஸ் ஹவு யூ ஹேவ் டு. ஆனா பொண்ணுக்கோ இங்கிலீஷ், உங்களுக்கோசம் கத்துக்கோங்க இங்கிலீஷ். ரைட்? வை மை மேடம் இஸ் தேர். ரைட். Now, third style is, yeah, my madam. Right. Third style is avoid. Avoid enna? I lose, you lose. நீயும் போடா, நானும் போறேன். Right. Fourth one is compromise. Fourth style is compromise. Compromise enna? I lose something, I win something. You lose something, you win something. Let's go on compromise. நான் கொஞ்சம் வின் பண்றேன், கொஞ்சம் விட்டு கொடுக்கிறேன். நீ கொஞ்சம் வின் பண்ணு, நீ கொஞ்சம். That is known as compromise style. Last one is collaborate. Collaborate means I win, you win. This is the main crux of bargaining. நானும் win ஆறேன், நீயும் win ஆ. This should be the criteria for negotiation. So normally big companies la kuda enna padukona, they don't go for arbitration. They will sit. Whenever big companies are sitting, they will be having certain criteria for negotiation. Simply நீவா சொல்லி இருக்காது. Scientific they will prove this is the outcome of this decision. So these are the 5 stages of negotiation styles. First one is compete, I win, you lose. Second one is accommodate, I lose, you win. Third one is avoid, I lose, you lose. Fourth one is compromise, I lose and win some, you lose and win some. Collaborate, I win and you win. So these are the 5 styles. Next one is, there are 8 stages of negotiation. 8 stages. So you want to have a successful negotiation. The entire negotiation process pass through this 8 stages. First stage enna? Prepare. First stage is prepare. Prepare. இங்க என்ன நடக்கும்னா, what you want. உங்களுக்கு என்ன வேணும், உனக்கு என்ன வேணும், உனக்கு என்ன வேணும். First we have to know. Second stage is open. Open means put your case. So what is your case and what is your case? This is second stage. Third one is argue. Argue means support your case. உனக்கு இது ஓணுன்னு சொல்ற, எதுக்கு வேணும், what is your legality behind this. Third one is argue. Fourth one is explore. Explore பண்ணணும். என்ன எக்ஸ்ப்ளோர் பண்ணணும்? ஒரு அண்டர்ஸ்டாண்டிங் எக்ஸ்ப்ளோர் பண்ணணும். What are the possibilities to reach and decide outcome? Explore. You have to explore. This is the fourth stage. Fifth stage is signal. Signal. It implies, yes, I am ready to work together. Yes, both the parties are accepting to work together. Next one, package. So, இது நான் ஒத்துண்டா எனக்கு என்ன வரும்? What is the thing I am going to get? It assembles potential trade. Seventh one is close. Reach final agreement. Eighth one is sustain. Seventh one is close. Reach final agreement. Eighth one is sustain. Make sure what is agreed happens. What is agreed happens. Now, I will tell you one example so that you will come to know what is meant by negotiation. You are residing in a locality, right? Now, certain factory are creating pollution in your locality. Or pollution create பண்ணிட்டு factories are creating pollution in your locality. Now, you want to have so many options. And the locality elders will be there. They want to curtail this problem. Now, first they have so many alternatives will be there. Whether call the factory people and negotiate, first thing, to curtail the pollution. ஒருவேளை factory people வரலன்னா straight away shall we go and file a complaint in pollution control board. This is another alternative. நம்மளுக்கு pollution கீழ adjudicating authorities will be state pollution control board, central pollution control board, next one is national green tribunal, then from national green tribunal you have to come to Supreme Courts. You understand? These are the array. Yes, shall we go for negotiation with the